We're going to look at the following prescription issues. First of all, we're going to look at section 11.3, 11.3a, and 11.3b. This is part of the new discoverability test brought in by the Prescription Scotland Act 2018. We'll then look at section 6.4 and section 6.4a in relation to fraud or error. Then look at the 5-year short prescriptive period, the 20-year negative period. And we'll then come on to look at standstill agreements. And this is a new, or certainly a novel thing for Scotland under section 13 of the Prescription Scotland Act 2018. Standstill agreements will now be lawful. Whereas before there was a degree of doubt. We'll also look at limitation, and finally we will look at relevant case law, recent cases on prescription. Now there's been some more recent relevant case law on this matter. The case of Gordon's trustees against Campbell, Riddle, Breeze Partners, UK Supreme Court, UK Supreme Court 7-5. That's 2017 action. And what was held? It was held here that the creditor does not need to know if they have a head of loss. So essentially, it just mirrors the position in David T. Morrison against ICL Plastics. It's sufficient to start the clock if they did not obtain something that they sought or they incurred expenditure. Now, the claim prescribed when they didn't obtain vacant fields. They had issued a notice to quit had been issued, but it was defective, and the occupier should have left the fields on the date of the notice to quit, but obviously did not do so due to the defect. And the claim prescribed when they didn't obtain vacant fields. And in any event, legal fees had been incurred to recover the vacant land more than 5 years before the action had been raised. So they hadn't left the fields, and in addition to that, the legal fees had been incurred more than 5 years before the action was raised. There was knowledge of loss, and therefore, going with the Morrison against ICL Plastics decision, the claim was time barred.